So a short topic that I'm wanting to cover this morning is about the rights and entitlements of a detainee whilst in police custody. In the background here I've got a little slide which will also be available for anyone. Now, several cases recently that I've been involved with, the custody officers have shown a tendency to not be giving the detainee an actual hard copy of the rights and entitlements. And I just want to cover some issues around that and in relation to the fact that the detainee must be given a hard copy of these rights and entitlements and be permitted a reasonable time to read them as well. Now, although I'm referring to the Police and Criminal Evidence Act in relation to England and Wales, there's comparable legislation both for Northern Ireland and for Scotland. So if we're looking here at where it's at, PACE Code C, paragraph 3.1 states that when a person is brought to a police station under arrest, the custody officer must make sure the person is told clearly about their continuing rights. Now, I rarely ever see that a custody officer fails to give the verbal rights. These rights may be exercised at any stage during the period in detention. Under PACE Code C, paragraph 3.2a, the detainee must be given a written notice of rights and entitlements, so they must be given the written notice. Now, what we do have in existence, attached to the 2019 Code C of PACE, we've got this 10-page document which is produced by the Home Office, the Legal Aid Agency and the Law Society, and this should be available in your force to give to the detainee or a variation of such. But all of the information within these 10 pages is the rights and entitlements which the detainee is entitled to have. Now, the detainee must be given the opportunity to read that notice, so a reasonable time. So it's not just a case of, well, there's the rights, I'll put them in your property, off you go now to a process. They must be physically given this hard copy and then permitted to have a reasonable time in order to look at those rights and go through them. Then they're asked to sign for receipt of the hard copy. So again, from examination of numerous CCTV footage in custody, the electronic system now, the custody sergeant might be given the rights to the detainee and then they're saying, can you just sign on the screen that you've got them? But on that screen there's also a sentence saying about, and I have been given a written notice. And in a lot of circumstances that person hasn't. Concerning the right to legal advice, no police officer should at any time do or say anything with the intention of dissuading any person who is entitled to legal advice in accordance with this code, and that's PACE Code C, section 6.4. So, for example, where any police officer involved in the case or in the custody of the person might then say, you don't want a solicitor, it's only going to delay you getting out. You must not dissuade a person from obtaining legal advice. The custody officer must act without delay to secure the provision of such advice. That's PACE Code C 6.5. So an example there might be the custody sergeant's going through the booking in process. The detainee says that they want a solicitor. Now, if there's detention officers or other custody staff available who are able to put that call in, then that is a reasonable opportunity then for them to put the call in for the legal advice. You don't have to wait for the custody sergeant to finish the whole process to then make that call. So it's looking about without delay to secure. So if there's people available, they should be making that call. 6.5 states the exercise of the right of access to legal advice may be delayed only as in Annex B. So there's certain issues then which might be authorised by an inspector or a superintendent. Now, whether legal advice is requested, the custody officer must act without delay to secure provision of such advice. But note, there may be grounds to delay notification of arrest. So, for example, if persons are outstanding or property is outstanding, it might be agreed that notification of the person's arrest is to be delayed, but that's separate and should be assessed separately in relation to the solicitor. So it might be authorised, no notification of arrest, but they still require the notification of legal advice. In relation to drink drive procedures, so this is one which I've noticed a few times as well, where the detainee, they're getting booked in and the custody sergeant may or may not have one of these hard copy rights and entitlements, which if they do have the hard copy, what I often see there is they just pop it into their property and say there's a notice there that you can read when you're released, but we're going to take you right through to the drink drive procedure now. Now that person then might be saying, well, I want my legal advice, I don't understand, and the custody sergeant saying, well, you're not entitled to delay the process for it. And then this back and forth argument commences between the detainee and the custody sergeant. But if we look at what the rights are in relation to PIS and indeed on this notification, it would just be much easier if page 9 of the hard copy, if the custody sergeant or custody staff went to page 9, and I've highlighted here on page 9, drink drive and drug offences. If you are under arrest because of a drink drive offence or for a drug drive offence, you have the right to speak to a solicitor. That right does not mean you can refuse to give the police samples of breath, blood or urine even if you have not yet spoken to a solicitor. So simply by showing that would then negate the argument then in relation to did the person fail without reasonable cause. Because I've seen examples where the custody sergeant's arguing with the detainee saying, I don't have to show you where in the law it says that you're not entitled to wait for a solicitor. Well, it's actually on the rights and entitlements for the detainee, and it just then makes the conviction or process safer rather than given an opportunity to argue at court that PACE and the procedures were not complied with. So in summary, a custody officer must give a detainee a hard copy, a physical hard copy of the Notice of Rights and Entitlements. So the standard copy is 10 pages, and this is produced by the Home Office, the Legal Aid Agency and the Law Society. And in addition to physically being given this in their hands, so subject to their capacity and capability, they must be allowed a reasonable time in order to look at those rights and entitlements too. It's not sufficient to just say that there's a laminated copy that they can look at if they want, and this one copy is shared between people. They must be given their entitlement, which is their Notice of Rights and Entitlements, and given a reasonable time in order to look at them. And I hope that's been of some benefit.